Hi everyone, welcome to the U-Visa Nuts and Bolts of Filing training. My name is Amy Cheung. I'm a senior staff attorney at Tahirih's Greater DC office. We'll be talking about how to show that your client is eligible for U-Visa, and we'll also be sharing some practice pointers on assembling and submitting the actual filing. First, this training is not going to go in depth into the eligibility criteria. We'll be walking through each of the 4 elements for visa eligibility to talk about how one might find the evidence to prove each of these elements. So there are 4 eligibility criteria for a U-Visa. Client show that she is the victim of a qualifying criminal activity in the United States, that she possesses information about that crime. She has been helpful, is being helpful, or is likely to be helpful to law enforcement in the investigation or prosecution of that crime. And she has suffered substantial physical or mental abuse arising from that qualifying criminal activity. We'll go through each of these elements one by one to talk about what kind of evidence you might be able to submit to prove each one. That in U-Visa applications, the applicant always bears the burden of proof. Third is preponderance, but USCIS must consider any credible evidence in evaluating whether or not she's met her burden. And so what it means is that you're submitting credible evidence that she is eligible for a U-Visa, USCIS must consider it unless you have some reason to think that the evidence itself is not credible, right? And so typically you're talking about making sure that the evidence that you're submitting is consistent internally and externally. Let's get started with the elements. First, you need to show that your client is the victim of a qualifying criminal activity in the United States. There's typically, in a U-Visa case, going to be quite a bit of third-party systems evidence to be able to show this. So, for example, sometimes there is a police report or even the arrest report for the suspect. If there was a criminal prosecution, then there should be a court disposition. Also, you would have to submit a law enforcement certification, which is the 918 Supplement B, and on there will be noted the qualifying criminal activity, any statutory citations, and also noting who was the victim of that crime. We also include a printout of the relevant criminal statute, show that the criminal activity in question is one of the qualifying crimes for U-Visa purposes. You also need to include a declaration from your client in which she explains that she was the victim of this crime and what transpired. Next, show that she possesses information regarding that crime. And you'll hear that a lot of the information, a lot of the evidence that we would submit is quite similar to the evidence that you would submit to prove the first element. So, for example, here you would also be looking at a police report that shows that your client provided information to the officers. Also, perhaps if there was a criminal prosecution, she may have been subpoenaed as a witness. Law enforcement certification would also has a field where the certifier can explain what information the applicant had or provided, and then also she can explain this information in her own declaration. Next, show that she has been helpful, or is being helpful, or is likely to be helpful to law enforcement. And again, it's very similar evidence. So the police report, again, is subpoena, the law enforcement certification, and her own declaration. The last element is a little bit different. It will show that she has suffered substantial physical or mental abuse arising from the qualifying criminal activity. So there may be information about this in the law enforcement certification on the form I-918 Supplement B. But if so, or if not, there may be other evidence. So, for example, there could be medical records, there could be photographs of her injuries. Many of our clients go to a counselor or a therapist, then you can get a letter from that counselor to the psychological and emotional harm that your client experienced. Sometimes you'll have a psychological evaluation, and you would certainly address this in your client's declaration as well. Keep in mind that USCIS will consider evidence that the qualifying crime aggravated a pre-existing condition or that a series of acts may have caused substantial abuse, even where no single act, including the qualifying crime for which you're seeking certification for the U visa, rose to that level. Especially important in domestic violence cases, where, for example, your client may have experienced a very long history of physical and psychological violence, and perhaps what she finally reported to law enforcement was not a particularly serious incident in that long history of domestic violence. The crime in question didn't give rise to substantial physical or mental abuse in and of itself. In the declaration and in the counselor's letter and the other records that you're submitting, you can explain the long history of trauma, the long history of victimization, where the history of abuse in the act rises to the level of substantial physical or mental abuse. All right, even if your client shown that she meets all 4 elements for U visa eligibility, it's admissible able to receive a U visa unless she is granted a waiver of inadmissibility. All of the grounds of inadmissibility at INA Section 212A. So that section, if you find that your client is subject to one of those grounds, or more, one or more, then sure, your client would need a waiver of inadmissibility. We'll have a form of the waiver later on, but first, we'd like to address what a waiver is and what kind of evidence you would show to make your claim. First thing is discretionary, and so the standard that you're looking at is whether or not granting the waiver would be in the public or national interest. The client would want to show remorse and positive equity, so ties to the United States. You want to portray your client as sympathetically as possible. In terms of the admissibility themselves, the most common ones that we see are unlawful entry, being a material misrepresentation for purposes of obtaining immigration benefits. This would be tried to obtain some kind of immigration remedy or perhaps a visa to the United States. Your client has made false claims to U.S. citizenship, and this could be, for example, in the employment context, or she have registered to vote when she was not a U.S. citizen. Also, if your client has previously been removed or deported from the United States, if your client has made multiple unlawful entries to the U.S., criminal convictions for drug offenses or crimes involving moral turpitude, alien smuggling, including if your client unlawfully brought children to the United States, and also not having a passport. There are some of the most common ones that are applicable to many of our clients. Now, in terms of these that you're going to submit, it's going to depend a little bit upon the of admissibility that applies to your client. So, generally speaking, the evidence that you'll want to submit is going to include an affidavit in which she expresses remorse for her actions and shows evidence of her rehabilitation. If your client has only really minimal and not very severe grounds of inadmissibility, then it's possible to include her explanation for her waiver application in the same affidavit that she's submitting to the U visa. However, if she has more serious or more numerous grounds of inadmissibility, then she would want to submit a separate application, affidavit. Client has criminal convictions, would need to include the certified disposition from the court. Sometimes USCIS will seek the arrest reports or police reports, but generally wouldn't include those proactively and would only submit them when and if USCIS requests that. In addition, we want to show positive equity. And so we're talking about ties to the United States and contributions to the U.S. You're trying to show that your client is a positive contributing member of society. So for it to include birth certificates of her U.S. citizen or lawful permanent resident children. If they are LPRs, then we would want to include evidence of their status. If she's married to a U.S. citizen or a lawful permanent resident, we would include marriage certificate. Get character references from upstanding community members. That can be very helpful. Also, evidence of gainful employment, of paying tax returns, evidence of her involvement in her children's education and health care, photo letters and cards showing a relationship between her and her children, evidence of volunteering, for example, if she has volunteered at community groups, or the PTA, for her religious organization, anything like that. Keeping quality of rehabilitation evidence and positive ties to the community that you would want to submit will depend on the number, recentness, severity of the immigration and criminal violation that needs to be waived. So, for example, if your client has really minimal grounds of inadmissibility, like let's say she unlawfully and doesn't have a passport, then the evidence you submit doesn't need to be that extensive, and you would just include the explanation for those waivers in the affidavit that she's submitting for the EU visa. Where if she has criminal convictions or has a lot of violations, then you're probably looking at a more extensive waiver application. Keep in mind that if your client's criminal history does not make her inadmissible, U.S. can still consider that criminal history or immigration violations in deciding whether or not to grant the EU visa in the exercise of discretion. Even where the criminal history wouldn't make her inadmissible, you still want to include certified dispositions, you still want to include evidence of rehabilitation, and you still want to address those arrests and convictions in her affidavit. And that does still need to be disclosed. In terms of the affidavit, the principal applicant must include a detailed affidavit addressing each element of her U visa eligibility. And as I mentioned earlier, if she is inadmissible, but grounds of inadmissibility are relatively minor, then those can be addressed in the main affidavit. If they're more serious, then she would want to consider including a separate affidavit for the waiver application. Generally speaking, derivatives do not need to include their own affidavit. The option would be if they're seeking their own waiver of inadmissibility, or they have their own negative discretionary factors, such as criminal history that doesn't make them inadmissible. If you're putting this affidavit, I recommend that you interview those witnesses and help them draft the affidavit, just as you're doing for your principal client. This is because I find that witnesses are not really sure what kind of information needs to be included, and also don't understand the level of detail that would make for the most helpful affidavit. Any affidavits or declarations should either be sworn or notarized. It doesn't actually matter to immigration whether or not they are sworn or notarized, but they must be one or the other. All right, so when you're filing the application for the principal applicant, there are a number of forms that need to be included in application kit. First and foremost is going to be your G28, which is your notice of appearance. Is the I-918, which is the U visa application for your client, and with that you would want to include 2 passport photos. You would include the I-918B, which is the law enforcement certification. I recommend that you file the I-765 under category C14. This is an application for employment authorization and would be relevant when your client gets on the U visa waitlist and is issued deferred action. These visas are subject to a really extensive backlog these days with USCIS. Typically, before your client is granted her final approval for the U visa, she is placed on the U visa waitlist while you're waiting for the U visa itself to become available. While on the waitlist, she is granted deferred action and is eligible And when that you file this along with the initial filing, because if you wait until she gets on the wait list, so there will be a more extensive delay for her to receive the EAD. Along with the 14765 application, you would need to include a 765 sheet and 2 passport photos. In addition, you would include a request for fee waiver unless your client is paying herself. The I-918 U visa application is free. The 765 under category C14 and the request for waiver of inadmissibility or form I-192 both require a fee. And so if you're not able to pay that fee, then she can request a fee waiver on the form I-912. And we'll be talking about that in more detail later on. And I mentioned earlier, if your client is inadmissible to the United States, then you need to file a request for waiver of inadmissibility on form I-192. The derivatives are a little bit depending on whether or not your derivative is inside the United States or outside the United States. So if a client is outside the United States, you would submit the I-18 Supplement B, then one for each of the derivatives. So let's say your client has 3 children, all outside the United States. Each of them's children would need their own supplement A. In addition, the derivative is inadmissible to the United States. Then the derivative would need their own form I-192, request for waiver of inadmissibility. The derivatives who are outside the United States are not inadmissible, and so they would not use this form. For example, let's say your derivative client was previously in the United States and was deported. Your client, that may be inadmissible to the United States and would need a waiver application. And those of inadmissibility apply to derivatives as for principals. And so we'd still be looking at INA Section 12A to determine whether or not your derivative is inadmissible. Derivatives show evidence of their own identity, so this could be a copy of the birth certificate, keeping in mind that any foreign language documents must be translated into English and accompanied with a certification of translation. It also include a copy of the passport. You would include evidence of the relationship between the derivative and the principal to show that the derivative is qualified to be a derivative. You may have a derivative who is your principal applicant's spouse, sibling, parent, or child, depending on the circumstances of your principal client. And on what the relationship is, you would want to show a document showing that relationship. If in the United States, then you'll need to show slightly more extensive documentation. So first, you need to enter your appearance for the derivative as well on the G28. You would still need the I-918 Supplement A. You would also need you would need to file the work authorization application for the who is in the United States. There are actually 2 applications for employment authorization that would need to be submitted. One is the I-765 under category A20. This is for the employment authorization document that will be issued once the final U visa application is approved. Also need to submit a 765 under category C14. This is very much like the one that you're submitting for your principal client, and this will kick in when the derivative and the principal get on U visa waitlist and are issued deferred action. You would also need to submit the I-77 worksheet, which is relevant to the I-765 under category C14. Earlier, if your derivative is inadmissible, they need to file their own form I-192 accompanied by their own affidavit, evidence of rehabilitation and time to the United States, and any certified disposition for criminal history. The same evidence that you would be submitting for your principal, the evidence that you would be submitting for your principal applicant if your principal were inadmissible. Also, if you're filing the I-765 or the I-192, you will need a fee waiver unless your derivative or principal is going to pay the fee for those applications. is that you can use one fee waiver form for the entire family as long as they're part of the same household. So if your principal applicant is filing for a fee waiver, then they can just include their derivative on that same fee waiver form and don't need a new fee waiver application. Also, like for derivatives who are overseas, a derivative in the United States would still need to evidence their own identity. So this could be their birth certificate and or passport. You need to show evidence of the derivative's relationship to the principal. And so depending on what that relationship is, you could be looking at a birth certificate, marriage certificate, etc. You would have 4 passport size photos. This is 2 photos for the A20 767 and 2 photos for the C14 767. That if your derivative is under 14 years of age, their parent can sign on their behalf. Or if the derivative is 14 or older, they will need to sign their own form. Is that we recommend speaking with the derivative individually in case there's information that the principal doesn't know about and the derivative feels uncomfortable disclosing in front of the principal. This is especially when you're completing the I-918 Supplement A, which asks a number of questions regarding your derivative client's criminal and immigration history. This is relevant to completing the I-192 request for waiver of inadmissibility. All right, so on completing the forms themselves. First, we always recommend that you go to uscis.gov to get the forms. Even if you've previously filed a UVisa application and have a copy of the form saved on your computer, we don't recommend using that because USCIS does update the forms often. And also, sometimes, even if the form doesn't have any changes, they'll update the edition date, and they would only accept the newest edition. To specifically tell otherwise, please go to uscis.gov to get the latest edition of each of these forms. On the J, you want to print this on blue paper, put your address as the mailing address. This is because oftentimes our clients are very mobile, they move quite frequently, and also their mail delivery can be less consistent and less secure than the mail delivery to your office. You might want to consider putting confidential address as the client's address on the G28, and recommend checking both of the boxes above the client signature line on page 3. This is so that you get all of the correspondence related to the case, and that so that when the employment authorization documents are finally issued, that they will come to your office. This will ensure that you and Tahirih will have a complete record of the correspondence in the file, and then once you receive the documents, you can pass them on to the client. For the I-918 form, we again recommend putting your office address as a safe mailing address. And also, you'll see that there's a field for the I-94 number. If your client entered the United States lawfully, whether it was on a visa or through parole or whatever it was, she may have she will have an I-94 number, and you can find this number on the CBP website. Derivatives on the form I-918A, if your derivative is outside the United States, he or she does not need to sign. The principal will sign on their behalf. For Form 765, for the principal, you're only filing one, and it's under Category C14. For derivatives, you're filing 2 of these forms. One is under C14, and the other is under the Category 820. You'll only file the 765 if in the United States. So even if your client, whether it's the derivative or the principal, already has an employment authorization document, if an authorization document has been issued under a different category, for example, let's say they previously were a student and had an EAD under that category, be applying under permission to accept employment and not as a renewal. This is because they're first time applying under this category. For anyone applying for a 765 under Category C14, you would also need to submit a 765 worksheet, which is also available at uscis.gov. You'll see that there's a very extensive section section where you can provide an explanation for why your client needs an employment authorization document. You do not need to fill out this section completely. A very brief explanation, such as I need to work to support myself and my family, is sufficient. Also, in filling out the I-192 form, you, like in the I-918, consider putting confidential address for your client's current address. You'll also see where your client is being asked to explain the intended location of her entry, the port of entry, how she plans to travel to the United States, and when she plans to enter the United States. In the United States, then you can put not applicable for all of these fields. Also, the approximate length of stay, you can put indefinite, and as to the purpose of the stay, you can say that it's to obtain non-immigrant status. See examples where people have put to a non-immigrant status and assist field enforcement in the investigation or prosecution of the crime. That's fine, but it's not necessary. When completing Form I-912, which is the request for fee waiver, what to keep in mind is that these are routinely approved by the Vermont Service Center. So you really don't need to go overboard in terms of your explanations or evidence as to why your client requires a fee waiver. The most commonly applicable ground for our clients is that their household income is under 150% of the federal poverty guideline. And you can form instructions, which are also available at USCIS.gov, which individuals are counted as part of the household. You may find that your client lives with a number of family members, all in the same house, but that they're not necessarily part of the household. So for an unmarried partner working in the house are not household members, but any financial support that they're providing should be included. Also keep in mind that you can use one I-912 for the principal and derivatives as long as they share the same house. Earlier, the reason why you may need the fee waiver is because the I-192 and the I-765 require a fee. So unless your client is paying the fee, then they will need a fee waiver. In terms of the evidence, as earlier, the ground for fee waiver eligibility that most of our clients are that's applicable to most of our clients is going to be household income under 150% of the federal poverty guideline. And so I usually include a copy of the federal tax return. If that's not available, or if that income information is not accurate, then you might be looking at including a recent pay stub or a letter from the employer regarding your client's income. You could also use a public benefits award letter if there are members of the household who are receiving public benefits. If your income is over 150% of the federal guideline, then you may be looking at applying on financial hardship. In that, you would complete the relevant section of the I-912, and you would include evidence such as bills, bank statements, tax returns, or recent pay stubs, and just brief explanation as to why, despite their income, they're not able to pay the filing fee. Again, keep the explanation of the evidence does not need to be extensive. That there is one other category of eligibility for fee waivers, and that's for an applicant who receives a means-tested benefit. In most clients do not receive means-tested benefits themselves. You may have children receive a benefit, and your client may even be listed on the public benefits awards letter at head of household because the adult receiving the benefits kids may have. But the kids are actually the ones who are the recipients of that means-tested benefit. And so if your client does not herself receive this benefit, she cannot apply for a fee waiver based on that ground. All right. Here you use the application, you will include a cover letter. In this case, there's no need to brief the case unless there's some issue that is particularly legally complex. And your answer will tell you if that is the case. However, the detailed cover letter that explains why your client meets each of the UVA eligibility criteria. You would also cite to the evidence that supports the client eligibility. And I'll keep in mind that for the most part, case law on new visa cases. There's some exceptions, but for the most part, there's no case law, so you wouldn't be citing the case law. A fee waiver, then you would want to be sure to put in very large, flashy font on the front page at the top that you are requesting a fee waiver. Because when the Vermont Service Center is processing the applications in the mailroom, one of the first things that they look for is the fee. And if they see a fee and they miss the fee waiver, then they could reject your application. And so ensure that you put in very eye-catching font on the front that you're seeking a fee waiver. Practice pointers. Any and all foreign language documents must be translated into English and accompanied by a certificate of translation. A translator does not need to be court certified or otherwise certified in any way. It can be somebody who just is willing to certify that they are competent to translate this document from the language in question into English. And the mentor can provide you with the language for the certificate of translation. Also want that you're checking all of the supporting documents to make sure that you're not submitting anything that could raise any red flags for immigration. So, for example, say you are filing for a fee waiver and your client is submitting evidence of their income. If you see any pay stubs with a fake social security number, you wouldn't want to submit that pay stub. Like use tax return with people listed as dependents who are clearly ineligible, or where your client has said that she's had a household when she's clearly ineligible for that designation, then you wouldn't want to submit that tax return. We're guys to be tax attorneys. We're not tax attorneys either. We're saying that if you take a look at the tax returns and there are some issues that are obviously problematic, you are careful about that. But if you see that there's inaccurate income information on their public benefits letter, you wouldn't want to submit that documentation. Also, if you're providing you evidence of their identity in the form of a driver's license for a state where they don't live, or if your client is living in a state where they're clearly ineligible for a driver's license and some have a driver's license, you might want to submit that. If you ever come across problematic documentation like this, please reach out to your Tahirih mentor and we talk through issues and analysis, and also talk through what alternatives you may have. So, would want to review any prior immigration filings by your client. Some of your clients have submitted documents to the immigration agencies previously. So, for example, maybe they were in remote proceedings in immigration court, maybe they applied for temporary protected status through USCIS. You can try to obtain copies of those documents, whether through or your client has their authors, or perhaps your client's former counsel, just to make sure the information that was previously submitted is consistent and accurate. Inconsistencies or errors, reach out to your Tahirih mentor. We can talk about how to address those. If any dates and details that you're submitting with the UV's application are consistent across the forms and supporting evidence, keep in mind USCIS is supposed to consider credible evidence. You want to bet your evidence is credible. Also, about criminal history with your client, consider running a background check. So the term of a background check would be an FBI background check. These are national. Unfortunately, they take 5 to 6 months to come. You may not have time for that. State and local checks are typically faster and could be available online, and could even be instantaneous depending on your location. So at a very least, you could run a quick search to see if anything pops up. Deadline. Speaking in visa cases, the deadline we're talking about is the expiration date of the law enforcement certification, or the 918 supplement. This point is 6 months from the date that it is signed, meaning that CIS must receive the UV's application by the expiration date. USCIS does sometimes take several days to process mail. They also sometimes erroneously reject filings, such as if they don't realize that you have a fee waiver included, and definitely want to plan to mail your filing at least 2 weeks prior to the deadline to ensure that USCIS receives it prior to the expiration date of the law enforcement certification. The expiration date is listed in the regulations as 6 months from the date that it's signed, not listed as a matter of days. And so USCIS interprets 6 months as the date before the 6th-month anniversary of the I-19B. So, for example, if the I-19B was signed on January 1st, 2017, the application must be received by USCIS on or before June 30th, 2017, and not July 1st, 2017. And that under certain circumstances, your deadline could be sooner. So, for example, if your client is under 21, she would include as derivative her parents and her unmarried siblings who are under the age of 18, in addition to a spouse or children. If your client is close to turning 21 and wants to include her parents or her siblings as derivatives, you would want to ensure that USCIS receives the application for your client's 21st birthday. The expiration date of the law enforcement certification is after that. Or a client is well under 21 and wants to include her derivative siblings, but one of her derivative siblings is very close to turning 18. You would want to make that USCIS receives the U visa application prior to the derivative sibling turning 18 years old in order to preserve their eligibility as a derivative. In terms of the application itself, keep in mind all documents should be single-sided. You shouldn't be submitting any original supporting documents unless specifically instructed. It should be original. The affidavit should be original. The I-18B law enforcement certification absolutely must be original. The documents like medical records and things like that not need to be original, and in fact shouldn't be. Not put any tabs on the application. USCIS will just cut them off. So we recommend using colored sheets of regular 8.5 by 11 paper as dividers for your forms and exhibits. We recommend 2-hole punching the top of your packet and binding with prongs. It's preferred not to submit your packet with any special commercial binding. So any passport photo should be labeled with your applicant's name and A number on the back. Many clients will not have an A number, and so then it would just be a question of putting her name on the back. And the those would go in a coin envelope or a small dime bag and could be stapled or paper clipped to the application. The forms go at the beginning, supporting evidence. Derivative forms and supporting documents would be grouped together and would each go at the end of the entire packet. And the packet is submitted as one big file. You would submit it to the USCIS Vermont Service Center via some kind of trackable delivery method, just FedEx or USPS certified mail, and the address. For checklists, you can see our e-library, which is available online, and your Tahirih mentor should have provided you with the password. For reference sake, you would include the cover letter, which includes the table of contents, money order if client is paying a filing fee, your applicant's forms with passport photos as applicable, principal's affidavit, evidence of the qualification and helpfulness, and a substantial abuse, and all evidence for the waiver of inadmissibility. And this with each of the forms and supporting evidence. Thank you so much. You use the case. If you have any questions, please contact your Tahirih mentor, and you can also please refer to our e-library for additional